Can you modify your custody agreement after the divorce? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Of course, you can modify the the custody agreement after the divorce. You can do that, but there's got to be certain circumstances that support it. The court doesn't willy-nilly change custody. The court will change custody if it feels there's a compelling circumstance that would cause the court to even revisit the issue, and B, once A is satisfied, yes, there's a reason to change custody and the custody should go to you, that kind of thing. So the court will entertain that, but it's got to be a strong reason not contemplated earlier. So for example, if you file a motion because your kids are getting older and you feel they need mom more, they need dad more, whatever, that's not an overly compelling reason because it's contemplated in the original custody order that the kids will age. The parents will age as well. Everybody will age. And so that in and of itself, without something else going on, is not going to be sufficient reason for the court to likely say, okay, we got to look at this again. You've got to have something. Now, for example, I'll give you, if the kid, for example, has to go live with a parent out of state because the climate is better for them and they've developed asthma, for example, that's a compelling reason. If the kid is failing and is truant from school, so therefore there might be a compelling reason to take the child and bring the child to the other parent because the other parent will, be on top of that school situation. That may be a compelling reason. These are compelling reasons why you might do that. Now, what about if the child just wants to go? If the child just wants to go, remember one thing. Express preference of the child is one factor, but there are 12 other factors that carry the day. And just because the child wants to live with mom now because she's running Disneyland and dad runs a more structured household, that doesn't mean the court's going to grant that request. So if that's what you're thinking, I'm going to file a motion to change the custody so that my kid wants to stay with me and the court's never going to say no to the child. Think again. The court will say no to the child. The court will say no if it finds that, the child only wants to go with you because you promised him a car. You see, the court doesn't go for that, so you got to watch for that. I would say this. If you are trying to determine how to negotiate these things and you're trying to figure out what's the best way for me to negotiate a fair custody, I think you should try to put yourself in the other person's shoes. If you're going to proceed with the notion that it's fair that I have 26 days of overnights a month and the other 4 you have, if that's what you're going into, be prepared for the other side to say, if that's a fair division, then you take the 4 and I'll take the 26. In other words, we have to look at it and say, would I think it's fair for me? If I would think it's fair for me, then you could argue it's fair to the other person. The minute you say, well, wait a minute, I don't like that, then you're probably not at the place where the other person is going to think it's fair. Now, does that mean that that should necessarily carry the day? No. I mean, if you've had the custody all along, if you were always the person who was with the kids all the time, the other person was never with the kids, then maybe it's appropriate that you should have the bulk of the custody. And maybe it's appropriate that the other person should have but very little. Every case is going to be different. So my suggestion is like this. We have to work out a framework that makes sense and is fair for all the parties around, including the kids. So in light of that, if you have questions about your case, you feel you want to present that and see what the court might do, of course, reach out and we'll be glad to give you some guidance on that so we come up with the right answer.